Hi everyone, Armine Bazikyan here from Bazikyan Law Group. Today we're going to be talking about the 4 things or the 4 items that you absolutely should not be putting into your will. These are very, very important things to be aware of when you're drafting a will for yourself, especially if you live in California. I'm a certified specialist attorney working in California, and I'm here to explain these 4 items to you, and then we'll get into what you should do with these items if it's not recommended to put them in your will. So number 1, the very first thing you should not include in your actual will is any healthcare decisions. What you want to do is make sure that your healthcare decisions are not in your will, because oftentimes if you're in the hospital, your will is not being read. No one's going to care what your will says because you're alive. You're not dead yet, right? You haven't passed on yet. So there's no reason why anyone would go and open up your will to read your instructions. So anything related to healthcare decisions you absolutely do not want to leave in your will. Number 2, retirement accounts or retirement instructions. You don't want to leave retirement assets distributed through your will, because a retirement account has a beneficiary designation, meaning that you can actually designate who you would like to receive that retirement account by way of the retirement company that's servicing this account directly. So you can contact them and name the beneficiaries rather than putting it in your will. Now, the reason you don't want this is because if it flows through your will, there might be some inconsistencies between your will, what your will says, as well as what the beneficiary designation you have on file with this company says. And we'll talk about what to do with those a little bit later, but essentially you're going to have conflicting information. So the third thing that you don't want to have in your will at all, because again, this goes back to in practice timeline and when things are actually going to be read from your will. You don't want to have any instructions about your last funeral arrangements, because again, when you pass away, your family's first step is not going to be, hopefully, to open up your will and see what it says. Hopefully they're going to focus on you and grieving you, and then when all of it is said and done, then they're going to open up your will and actually see what you wrote as far as your assets going to who and in what capacities. So you don't want to put funeral arrangements or your final funeral wishes in your will, because it's not going to be read immediately after your passing and before they make the determination of what to do. So that's the third thing. And the fourth item that you absolutely should not, or you should rethink about including in your will, is life insurance. Normally, again, we go back to the idea of beneficiary designations. We don't want conflicting information between your will and your beneficiary designation with the life insurance companies. So making a statement in your will about where your life insurance goes might not actually happen. It might be inconsistent or ambiguous, and it might create actually more problems. So those are the 4 items that we don't recommend you include in your will, or to at least be very cautious of including in your will. And now we're going to kind of talk about what to do with those 4 items instead. So let's kind of work our way backwards. Life insurance, like we said, life insurance companies have the option of allowing a beneficiary designation, which means that you can actually write down who you would like to receive your life insurance policy directly with the life insurance company, and they will follow your instructions at your death. It'll be a smooth transition and a turnover of those funds to the person that you've named, which is a much cleaner way of doing it. And then same with the retirement accounts, as we mentioned. Your retirement accounts should have a beneficiary designation, and they have different federal tax rules that they follow. So by naming a designated beneficiary, they will automatically roll over into that beneficiary's name without going through your will and creating possible inconsistencies. Now, with life insurance and retirement accounts, the reason why designated beneficiaries through the actual company itself is recommended is because, remember, in California, if you have a will, your will goes through the probate court, and the probate court determines fees based on the value of the assets, the amount of assets in there. So if you don't have to include more things in that probate case that you have to, why increase the value of that probate estate and thereby costing your family members more money? So if you can kind of give instructions on how to give that retirement account or life insurance outside of the probate estate, outside of the will, that's usually what we recommend doing, versus weaving it into your will and now all of a sudden your estate value has gone up by $1 million because you had $1 million life insurance, and all of a sudden that $1 million is going to cost an extra $25,000 in attorney's fees. Okay, so this is really for practical reasons that we say, do it this way versus that way. Now, Of course, there are some situations where it's more beneficial for it to go through the will, and it's always a case-by-case analysis, right? So don't just take my advice with a grain of salt. You have to talk to an attorney. You have to actually sit down with a professional and make sure that it's the right situation for you. Now, as far as anything related to healthcare or your last funeral expenses, like we mentioned, practically speaking, nobody reads the will until the person is actually passed on. So putting instructions about how things should be handled if you're in the hospital, putting those specific instructions in your will, it's the wrong document to put it in. The best way of doing that is through what we call a power of attorney for healthcare. Sometimes it might be called a healthcare directive. That's where information about how to deal with medical decisions goes in, not your will. Putting it in the will is just the absolute wrong place to put it, okay? Same goes for funeral instructions. Your power of attorney for healthcare, your agent, has control over the physical body for medical decisions, but also the physical body for disposition when you've passed on. Your healthcare agent can be the one that makes determination as far as how to dispose of your remains, what type of interment you would prefer. So your healthcare power of attorney or your healthcare directive should have the instructions related to your medical needs, your medical decisions, and also your last funeral wishes or your last cremation wishes or whatever it is that you want, whether it's green burial or whatnot, your specific instructions on what to do with your remains after you've passed on. So those are the 4 things that are kind of iffy and you don't really want to put them in your will. Let's review them again. We have your healthcare related instructions, your last funeral related interment instructions, anything dealing with life insurance and retirement accounts. Those are kind of the 4 little areas that we want you to kind of really sit down with an attorney and talk about before you make the determination to just automatically include it in your will. So those are the 4 things. We hope you found this video helpful. If you did, we'd love for you to share it. Leave us a comment below and let us know if you ever dealt with a situation with a loved one that put some of these assets into the will that created problems for you, or in general, if you've dealt with the California probate estate court system, we'd love to hear your experience. In any case, we hope you found this video to be helpful, and please also leave us instructions on what you'd like to hear more about, what topics you'd like us to do more videos on. Until next time, bye.